Hello, everyone. Welcome. Happy Monday. My name is Rabia Belt. I'm an associate professor at Stanford Law School. I'm a legal historian who studies disability and citizenship. And welcome and thank you so much for attending our event on David Sklansky's wonderful new book, A Pattern of Violence: How the Law Classifies Crimes and What It Means for Justice. We have many people to thank. First of all, thank you for attending this event and participating, and we are looking forward to your questions in the second half of this session. Also, thank you to the organizers, Debbie Mukamal, Jody Carrion, Monique Cho. Thank you to our co-sponsors, the Stanford Criminal Justice Center, the Stanford Center for Comparative Studies in Race and Ethnicity, and Stanford Law School. And thank you to our panelists for what I know will be a rich and thoughtful conversation. So first off, we have Sujata Balaga. Her work is characterized by an equal dedication to crime survivors and people who have caused harm. She's a former victim advocate and public defender, and she was awarded a Soros Justice Fellowship in 2008, which she used to launch a pre-charge restorative juvenile diversion program. In her most recent position as the director of the Restorative Justice Project at Impact Justice, Sujata helps communities across the nation implement restorative justice alternatives to juvenile detention and zero tolerance school discipline policies. Today, she's dedicated to using this approach to end child sexual abuse and intimate partner violence. And she was named a 2019 MacArthur Fellow, so she is an official genius. Welcome, Sujata. We also have Justice Tino Cuellar, who began serving on California's highest court in January of 2015. Previously, he was the Stanley Morrison Professor of Law and Professor of by courtesy of Political Science and the director of the Freeman Spogli Institute for International Studies at Stanford University. A fellow of the American Academy of Arts and Sciences, Justice Cuellar is a scholar of public law, complex organizations, and institutions whose research explores problems in administrative law and legislation, cyber law and artificial intelligence, criminal justice, public health and safety, and international affairs. So welcome, Justice Cuellar. Good to have you. And last but not least, Adam Sower is a staff writer at The Atlantic, where his work focuses on politics. He has received awards from the National Association of Black Journalists, The Root, and the Society of Professional Journalists. Sower was named a spring 2019 Shorenstein Center Fellow, and he received a 2019 Hillman Prize for Opinion and Analysis Journalism. I can give so many more details and accolades of all of our panelists, but we want to keep it short so that we can get to the conversation. But I encourage you to follow all of these people on social media. So you get to see Adam's cats, for example, or sort of follow Sujata's information and resources on her site for Impact Justice, follow Justice Cuellar's sort of thoughtful opinions on the bench, and also his scholarship at Stanford. And we also have our author. So Professor David Sklansky teaches at Stanford Law School, and he writes about criminal law, criminal procedure, and evidence. Professor Sklansky's past scholarship has addressed the law, sociology, and political science of policing, the relationship between criminal justice and democracy, the proper exercise and constraint of prosecutorial power, the interpretation and application of the Fourth Amendment, fairness and accuracy in criminal adjudication, the relationship between criminal justice and immigration laws, and the role of race, gender, and sexual orientation in law enforcement. He serves as faculty co-director of the Stanford Criminal Justice Center and is a beloved colleague. So just to outline how we are going to do this session, this is a webinar style, so you can't use the chat, but you can use the Q&A to pose questions to the panel. A link to buy the book will be in the chat. We're going to start our conversation just with our author. We're not going to do prepared papers or anything like that. This is going to be more of a talk show type conversation, although our subject is not the British monarchy. It's on something just as fraught and difficult, I guess, to have a conversation about violence in the law. And then we're going to open it up to the panelists, and then we're going to take questions for you. So first, David, I remember a couple of years ago, so when I would see you, every time I saw you, that you were just excited for a new, you told me a new revelation about information that you gleaned about violence in the law. And I was so lucky to be our participant in your seminar on violence. Violence is a tough subject to research. It's politically fraught, it's emotionally taxing, and it's intellectually difficult to navigate. So what motivated you to embark on this project?
Well, thank you for that question, Ravi, and thank you for moderating this session. I also want to thank Tino and Sujatha and Adam for being part of this. I wrote the book because I really wanted to jumpstart some conversations about the way in which the category of violence gets used in discussions of criminal justice and the legal system more broadly. And so a discussion like the kind we're going to have today is exactly what I had in mind. And the reason why I thought these discussions are so important is it became clear to me over the last several years that two of the biggest stories about criminal justice over the course of my career, both of which are tragedies in their way, have their roots in how we think about violence. One of those stories is the story of mass incarceration, and the other story is the collapse of police reform. Mass incarceration has been driven and is now sustained in large part by the idea that there's a category of people, violent criminals, who we have to treat differently, who we have to put to one side when we're thinking about criminal justice reform, who have to be bracketed out of any conversations about lenience or rehabilitation or restorative justice. So that's one part of what made me want to write the book. The other big storyline about criminal justice over the course of the time I've been working on it is the collapse of police reform, which 20 years ago seemed like a huge success. Everyone, including most progressive police executives, thought that policing had been fixed. We had figured it out. I say everybody thought this. It's not true that everybody thought it, but lots of people thought it, and lots of academics thought it. Even people who didn't think policing had been fixed generally thought that policing was going in the right direction. And it's very hard to find people today who think that. And I think that's in large part because police reform didn't address police violence and was blind to in many ways, the problem of police violence. So I started with this sense that in criminal law, we often make too much of violence. And in regulation of the police, we often make too little of it. And I wanted to figure out why that was.
Thank you. It seems as if with the first aspect of what you're talking about with reform efforts for mass incarceration, violent people were treated as exceptions so that we can change mass incarcerations, we can get people out of jail, but the people that are really supposed to be there, quote unquote, are the people that are violent. And then when it comes to the second issue with police reform, that at the same time that those who are violent, who are police officers, were treated as exceptional too, right? That they were bad apples, that they're easily identifiable. And both with both of these, that violence is treated as a way to categorize people as exceptional. But from reading your book, it seems as if it's much harder to make those distinctions than we may think. So, how do you categorize, or what are you noticing, or sort of the main themes when it comes to how the law thinks about violence?
Well, I think inside criminal law, the law does exactly what you've said, which is to imagine that a sharp line can be drawn between violent crimes and other crimes, and that we can use this line to escape from the real difficulty of criminal law. The real difficulty of criminal law is that in every case, we feel torn between two instincts: the instinct toward understanding, the instinct that there but for the grace of God go I, and the instinct toward judgment, the sense that people are moral agents and need to be held accountable. So it's tempting to think that maybe we can escape that problem just by distinguishing between two different categories of people who commit crimes, that there are some people who deserve understanding and other people who just have to be locked up. But the world is way more complicated than that. And you can't escape the hard problems of criminal law that way.
Mhm. What were you most surprised about when you conducted your research for the book?
I was surprised at how recent this idea is that that violent crime is a category apart. It's so much a part of how we think about criminal justice today that it seems natural. We distinguish in our statistics between violent crimes and property crimes. People who commit violent crimes are generally ineligible for diversion programs like drug courts or veterans courts or mental health courts. People who commit violent crimes are often ineligible for early release from prison. When a criminal justice reform proposal is put forward, like restoring voting rights for people who have spent time in prison, or facilitating early release of people who are in prison during a pandemic, for example, often the debate immediately goes to whether or not we have excluded violent offenders from this program. And people on both sides of the debate tend to tacitly agree that that's important to do. And the debate just is about whether, in fact, the violent offenders have been excluded. So I was surprised when I researched the book to discover that this idea that violent crimes are just a category apart is only about 50 years old. Before roughly 1960, people didn't draw that distinction. And it's not that people didn't think that murder was particularly bad or rape was particularly bad. It's that they didn't think that the world of criminal justice could be addressed by drawing a sharp, clean line between offenses that are categorized as violent and offenses that aren't. And I think it's because there was more recognition then than there is today sometimes that the category of violence, it sounds like it's simply a descriptive category, but it's really an evaluative category masquerading as a descriptive category.
So why do you think the 1960s was such a turning point?
I think it's hard to know for sure. I think a lot of things were going on. Part of it was a gradual turn away from violence more generally. The 20th century, and particularly the mid and late 20th century, was filled with horrific examples of violence on mass scales. It also, the mid 20th century was also characterized by some very inspirational examples of nonviolent reform movements. And I think those two historical developments, combined with the American experience in Vietnam and the events of the late 1960s, made people sensitive about, contributed to the sense that a sharp line should be drawn at violence and that violence was not acceptable. At the same time, crime inside cities was rising, and cities were increasing, the central parts of cities were increasingly occupied disproportionately by minority groups, by people of color. So when violent crime began to rise in the mid-1960s, as it had in earlier periods in American history, it was characterized in a different way than it had been characterized in earlier periods of American history when urban crime began to increase. So I think the story of the legal system's response to violence can't be disentangled from racism and America's long history of dealing with racial subordination too.
It's strikingly, violence as a term itself seems ostensibly race neutral. Is that part of its appeal?
Yeah, I think so. I think it's connected with what I mentioned earlier, that it sounds like an objective descriptive category. If you're distinguishing between violence and nonviolence, it doesn't sound like you're making a subjective judgment, let alone a judgment that can be informed by or motivated by race or other forms of group prejudice. But in fact, what we call violent is an evaluative decision. And the lines that the legal system makes in determining what counts as a violent crime and what doesn't count as a violent crime are fluid and subjective. And that gives lots of room for racial bias, which winds up shaping how the category gets employed.
Can you give a couple of examples for us?
Sure. So burglary is almost always categorized as a violent crime, but assault generally isn't categorized as a violent felony. It's not because it's not a felony at all. Aggravated assault is considered a violent felony. And the line between aggravated assault and simple assault, which determines whether we're dealing with something that is just a misdemeanor or something that's treated as a serious violent offense, has to do with whether there's serious bodily injury or whether a deadly weapon has been used. But both of those lines are highly subjective, because what counts as serious bodily injury varies from state to state and judge to judge, and so does what counts as a deadly weapon. Some courts say that shoes can be deadly weapons. Some courts say that hands can be deadly weapons if the assailant was trained in martial arts. So whether something gets categorized as an aggravated assault or a simple assault turns out to be a highly subjective decision, and that's a decision that can be and often does reflect racial bias.
So we've had two really major movements that have happened over the past decade or so that have been thinking about violence. So we have the Metoo Movement, so a phrase that was coined by a Black activist, Tarana Burke, in 2006, a movement that was at least in part intended to reveal the widespread nature of sexual assault and harassment and gender-based violence. Then we also have Black Lives Matter, a movement intended to protest police violence against Black people and challenge current mass incarceration and policing practices. And I knew this morning, that even waking up, that we were going to have yet another example of someone who is going to die at the hands of the police, and we did. So your book is not about these movements specifically, but I can think of themes perhaps that are reflective from the book that may speak to those two movements, thinking about movement activism and legal change with respect to raising awareness about violence. And then also thinking about race and gender. So just wondering, so for our last question before we open it up to the rest of the panelists, if you want to reflect on those.
Yeah, I think both of those movements have been hugely important in how we think about violence, but in somewhat different ways. So Black Lives Matter, I think, is the reason why police violence got put back on the agenda. It's quite remarkable when you look back at discussions of the police in the 1980s and 1990s, how marginalized discussions of police violence had become, how peripheral those discussions had become to the main focus of police reform discussions. And I think that's why the rampant militarization of policing went below the radar screen. And it's part of why the incredible number of people of color who are killed every year by the police wasn't part of the reform conversation. And it didn't become part of the reform conversation really until the Black Lives Matter movement forced it back onto the radar screen and forced discussions of police to pay more attention to the issue of violence. The Me Too is part of a much longer effort to advance discussions of the way that we think about gender relations and violence and other forms of abuse that work along axes of gender. And those discussions, I think, have a more complicated trajectory with regard to the issue of violence, because both with regard to domestic violence and with regard to the issue of and with regard to rape reform. Reformists did a lot of work initially by emphasizing the violence that takes place inside of intimate relationships and the violence that's inherent in the crime of rape. And in both cases, reformers later pushed to widen the lens, to look at the ways in which rape can come out of patterns of abuse and control that may not be recognizably violent in the most traditional sense at their origins. And the same is true of violence within intimate relationships, which reformers have been pushing for some time now to recognize is rooted in patterns of coercion and control. And the Me Too movement, I think, is part of that widening of the lens.
So I have many other questions on my list, but I definitely want to open it up to the rest of our panelists and participants. Just a reminder that you can pose questions in the Q&A. So Adam, I know you've written a lot about violence as a journalist. In particular, one of the things that you've talked about is with respect to police violence. Can you say something about how, what links do you see between the problem of police violence and the way violence is treated in other parts of the criminal legal system or other parts of the legal system?
Yeah, I mean, first I just want to say, this is a really fascinating book. And one of the things that I think David writes about that goes to the core of the current movement, the current Black Lives Matter movement, is, he writes that the police have frequently understood their role to include the use of unofficial, quote, extra legal force. They have assumed, usually with justification, that this is what the public expected of them. And I think, in some ways what we've seen is this layer of violence that occurs between police and people and regular people, but never reaches the inside of a courtroom. Because it never becomes part of like an actual criminal case. It's just something that happens, throughout the course of the day for people who live in neighborhoods that are heavily policed. And it seems to me that one of the big shifts in this conversation that David is writing about is that the invention of cell phone cameras means that it's much easier to capture these moments that occur outside, away from the eyes of a courtroom, and in this sort of nebulous world of, what are the cops allowed to do before they actually try to convict you of a crime. And that and that largely has to do with violence. That is the way that the police interact with people, and the way they use their authority, violently or not. Or when you think about all the so many of these clips that have gone viral, they involve police doing something that in many ways is routine. For example, the stop of the Black Army veteran that was videotaped that went viral, or kids in schools who are mistreated by police officers, teenagers or sometimes even younger than that. And it's all a part of this sort of expectation that David writes about that has been a part of police culture for a very, very long time. But also to say that it's a part of police culture almost minimizes it. This is a kind of tacit permission that they've been given because of the concept of violence that David is discussing, where anybody who is perceived as a violent criminal is therefore almost, pushed to the boundary of humanity and can be treated differently than you would treat, a supposedly respectable person. And obviously, that's, an extremely racialized. That's applied in an extremely racialized way, and that's something that I think, again, the invention of cell phone cameras has pierced the veil of something that I think was very hard to communicate, in the 1960s, or prior to the invention of simply cameras that you could just carry around everywhere, that these were things that were fairly common occurrences. They weren't necessarily acts of lethal violence, but they are acts of, they're nonetheless acts of violence that have suddenly become, that are now open to the scrutiny of the country in a way that they just simply have not been before. And I think that's a big part of, the shift in the conversation towards police violence and the reconceptualization of what that means that David discusses in his book.
It seems like with the cell phone footage that we have, it's still sort of talking about violence in a way that's pretty spectacular, so that we have something that we can see, something that looks horrifying. What are we missing if we just look at, say, someone who is physically brutalized by the police? And is violence the right way to think about what's happening? Very smart people.
You're asking us generally? Can any of us jump in?
Of course, yes.
Okay, so now that I've jumped in, I sort of regret it. I wish my very esteemed panelists would have gone first, and I'm really just honored to be here for discussion of this terrific and really interesting book by my colleague David Sklansky, with you, Rabia, with Adam, whose work I've read and enjoyed, and Sujatha, whom I've known a lot about, and it's great to connect. I think your question is terrific because the book is really a great work in that it takes apart a category that we so often take for granted in the law. Now, if you study what the courts do day to day, it doesn't take long to find out that we actually struggle sometimes to define the limits of various categories that either involve violence directly or that bear some pretty deep relationship, like what's a deadly weapon. And these are hard cases. They're not difficult because we're trying to just be overly legalistic or law professory with it. They're just difficult because even where the legislature has done some work to define these categories, and often the legislature is not, or when some public initiative approved by the voters has, at the end of the day, there are really tough questions around where you impose the extra criminal liability, often in the form of an enhancement, by the way, like something that the book talks about, but maybe the general public doesn't appreciate as much, is that sometimes what drives incarceration is not only, is this a crime or not? But all right, it's a crime, but is it a crime that carries an extra 2, 3, 5, 7 year penalty on top of what is already a potentially pretty intense sentence. So there's all that going on. But to go to the heart of your question, and here I'll express my own uncertainty about this. You know, I feel like the book has been so good at interrogating how we define violence, how we treat it differently in the policing context versus prisons, versus when somebody who's, you know, just somebody arrested by the police appears to engage in it, that it does leave us struggling with the question of whether the crux of the category does have some box we can define that is, you know, whether we want to call it morally meaningful, at least it might be ethically or instrumentally meaningful. And I'll just note here, I think the book admirably just kind of notes that this is a hard problem. I consider it a hard problem. I'll just note that I grew up in an area of the world that is in many ways very beautiful. We're talking northern Mexico, South Texas, but is also a place where, you know, violent activity defined in some defensible way is not as uncommon as one would like it to be. And you can look at works of psychology, works of literature like 1984 by George Orwell, and there is this sense that there is something to the notion of pain being caused. And I do think it's important to realize the part of the move the book makes is to remind us that there are truly brutal things that happen that may not cause pain or be defined as violence immediately. But maybe that doesn't mean that we should completely erase the notion that there is some special quality that violence can bring about that the law needs to take serious account of.
Robbie, I really love this question. And the book really helped me grapple with some of what I think I'd been thinking about since sort of my early involvement in what we used to call the battered women's movement. I really loved the chapter on that and the problematizing there and the incredible debates that were happening in the movement sort of as I was growing up in it. And this, you know, the way the book called me to really remember how dangerous it is to broaden the definition of violence within our current criminal legal system. And then also how dangerous it is to shrink the definition of violence in terms of the moral impact of and the real harm that is caused to people who experience things that might not fit either statutory definitions of violence or some of the more extreme, the reasons to limit it also. So, and it kept coming back to the same theme of this sort of limited rights pie that we have in the criminal legal world, right? Like when you think about the right to, for young people who are in the system, right, to have things limited means information limited means the person that they've harmed might not get access to the information about the thing that happened to them, right? And so we're always sort of carving things up in this way. And it made me sit with sort of where I landed, which was entirely outside the criminal legal system, right? And trying to not do more traditional reform of the system itself, but to sort of circumvent the system with restorative justice processes that operate entirely outside the system. And from that place, so I kind of questioned, why did you invite me for this panel? Because I'm doing work, and I mentioned this before, like I'm doing work that is really circumventing the system. And because of that, I'm able to define violence incredibly broadly. And so I do so both sort of from a place spiritually as a Buddhist, and also I'm very fond of another wonderful book that just came out recently, which is Kazu Haga's book on Kingian nonviolence called Healing Resistance. And Kingian nonviolence defines violence incredibly broadly, right? It defines it as all physical and emotional harm. So if we had that definition within our legal parameters, we would be filling our prisons endlessly, right? And yet when we remove the element of punitiveness, when the object of the processes that we engage with is non-punitiveness, but rather repair and accountability. And I think this is a huge problem with the way in which, at least in the United States and many other places in the world, we conflate the two. We think of them as the same thing, that accountability is necessarily involves punitiveness, right? And so, but if punitiveness is not a part of our processes, if we could think of other ways in which we could heal and prevent and repair harm, then we can have as wide of a definition of violence as might be needed, right? And so when I think about in the work of restorative justice that I do, we don't spend a lot of time trying to define these things with these terms because that's unnecessary. So we ask people who've experienced harm, how do they define harm? And so all of these terms fall away, and then we can start to think about, who is harmed and what do they need, and whose obligation is it to meet those needs, and how do we support those who've caused harm to be directly accountable to crime survivors' self-identified needs. And so in reading the book, it just really, on the one hand, I was, again, it really reified my reasons for leaving the practice of law. And I'm grateful for those of you who remain within the system to continue to think about these really, really complex questions. But it also caused me to double down on this desire to have a very, very broad definition and to think of experiments, ways, processes. Restorative justice is just one of countless ways in which we could think about how do we resolve and prevent harm as broadly as possible by defining, by making all the harms count, by making all the harms count. And I think that the critique of a broad definition could be that, well, if everything's violence, then it doesn't matter, right? But I don't think that that's, the ubiquity of a harm. We have harms that are ubiquitous that we still think are really bad, right? So if 1 in 4 girls and 1 in 6 boys are sexually abused, we still think sexual abuse is really terrible, right? It's everywhere, and we're still trying to do something about it. So I would just encourage us to imagine non-carceral, non-punitive ways in which we could address harm, all harms, so that we can have a really broad definition. So, but I, again, feel like there are some really important questions that need to be answered by those who continue to practice law. And I don't envy any of you. I feel like I get a free pass on this whole thing by opting.
Well, I actually have a question for you then, Sujatha.
I just want to say, I don't think Sujatha is too far away from law, though. I think she's still with us.
So we know you have a JD diploma there too, Sujatha. So, I was thinking less about ubiquity, but more when when I'm hearing you, it seems as if to define harm within sort of your paradigm is a call for recognition. It's a call for action. So it seems as if violence, what David was investigating was doing similar things, right? So there's part of it that could be that the response to violence or the response to harm is that we then put those people somewhere, right, which is a prison. But then there's another part in which what people have been asking for is that something has happened to me, and I want you to recognize that it was something that I did not like, and I need help for that to heal from that, and also someone else did it. And that, correct me if I'm wrong, David, it seems like that was part of the growth of violence in the book, right, in terms of the conversation about violence.
Yes, and I think you're absolutely right, Rabia, that one problem with the way in which we talk about violence today is the focus only on spectacular forms of violence or violence that seems spectacular. And I think it's particularly true with regard to the police, where we focus on police shootings, which we should, but we still tend to neglect the violence of ordinary day-to-day stop and frisk policing. That is, it is on the legal profession. That violence gets written out in part because of the way courts and lawyers talk about stop and frisk. Even the language stop and frisk, we don't call it a grab and throw against the wall. And I do think it's worth distinguishing violence from other forms of abuse. not because it's categorically the worst always, but because it often is particularly worrisome in particular ways. And I think not recognizing that the violence in stop and frisk was part of what contributed to the collapse of police reform. And what makes it hard to do any of this, and what makes it hard to recognize the importance of other forms of abuse other than violence, and what drives people to think they have to categorize things as violence in order for them to count, is the idea that violence is this master divide.
How are you defining violence there, David?
Well, I feel like if we didn't make so much of the distinction, it wouldn't matter as much exactly how we define it. But I would define violence as the use of force against another person. So, or the threatened use of force against another person. So that would mean that there's a lot of forms of really serious forms of abuse that aren't violent. And it's wrong to think that anything that falls within the category of violence is going to be categorically worse than anything that falls outside of it.
I'm persuaded by David's very tentative and very carefully crafted definition, and all the caveats he mentions about why it's useful to have a definition, but at the same time, not to overemphasize it. That said, I just think we're really locked in a dilemma, because this reminds me a little bit of William James's observations about the moral equivalence of war, where for a moment, yeah, I mean, you can invoke William James for many reasons, and he's right and wrong about many things, but I think he had this really keen eye for this irony that war so powerfully motivated society, but it was a very imperfect fit for what society should actually care about, right? And here too, it feels to me like the challenge is, if somebody wants to say, well, you know, the polluted river, that does violence to my community. There's a sense in which we'd want society to say, yeah, we recognize that that is a form of violence. And at the same time, no, the law should not treat it the same as somebody who stabbed you in the stomach. And, you know, it's hard. I think that's not easy, because I think the very point of expanding the category motivates ballot initiatives, legislators to act, courts to struggle with this, jurors when they're thinking about this. But we also want them to be technical and precise in almost a lawyerly way. And I think that we're going to be at this for a while, is just my point.
I wonder about the proximity of the damage to the body in relationship to the act, and how that relates to this. So when I'm thinking about the Adverse Childhood Experiences Survey and what we've learned over the course of a person's life, right? Like, this is decades of work by Dr. Vincent Felitti to examine the long-term effects of 10 forms of harm that happen to children, and the shortened lifespan of those who have an ACE, a high ACE, Adverse Childhood Experiences number. And so I always think about that, like what is violence, and how do, if we're talking about the impact on a body, right? What is the violence that is done to someone where there's child sexual abuse that maybe isn't extremely physically violent, but shortens a lifespan by decades, right? Or when we think about solitary confinement, literally doing things physically to people's brains, right? In ways that if we were actively doing that to someone's brain, that would be well beyond the bounds of the Eighth Amendment. And yet it's something that we allow. And so I just wanted to muddy the waters a little bit with a proximity question to, or the directness versus the indirectness of the physical harm to the body. That always makes.
I guess I think, Sujatha, that questions like that may be really important particularly in your practice, when you're figuring out what can you do as an act of restoration? How can you help people move forward? The nature of the harm that was inflicted may be important to understand. Where it isn't useful, I think, is in trying to figure out which kind of people deserve understanding and mercy, and which kinds of people don't. And that's a mistaken enterprise to begin with. And I don't know if violence is a worse way to try to to go along that path than any other, but it's just as bad as any other, and so we shouldn't use it for that. And if we don't use it for that, the stakes in defining violence get much lower.
So one of the other things I noticed as part of the book was that there was a lot of force that was enacted against people and that was permissive. So for example, with children, so you talk about how parents, for instance, can beat their children. Teachers can do the same thing. And we are moving out of this, but there has been an idea of sort of children being violent towards each other, or with sort of different spaces, like within the prison. So expectations that prisons are violent spaces. I keep on mulling over that 1960s turning point. And a couple of the things that I was thinking was that part of the wrinkles with defining violence is, one, violence is a way that we maintain hierarchy, and there can be violent lashing out. So going to Adam's work, right, when people that are on the top of the hierarchy feel that they're threatened. But also violence is an expectation of how we think boys and men grow up, and how they behave. So we think about bar fights, for example, differently than we think about, say, a stranger rape, right? So that there is sort of an expected idea of sort of masculine violence that seems to be part of the culture as well. And then we get really nervous when we think that there are sort of practices that might infringe on what boys and men can do, I would think, with their bodies. What do you guys think? Throwing the hypothesis out there.
I think you're right. In writing the chapter of the book on rape and domestic violence, I was struck by the emphasis that a lot of feminists have put on the drive for domination as more as the fundamental problem, both in intimate partner violence and in sexual assault. I was even more struck by that when President Trump started talking last year about the importance of dominance and dominating. He used those terms when he was discussing how he thought the police and federal authorities should respond to the protests last year against police violence. But I think that the same way that feminists have used the concepts of dominance and control to try to think more clearly about rape and intimate partner violence may be important for thinking about other forms of violence. And this is, I'm late to the party here. This is what Bell Hooks was writing about decades ago.
Adam,
I think that's I think that's a really interesting question because, growing up, there was an expectation that as a young man, as a teenager, that you had to have a certain capacity for violence, even to avoid violence. If you did not want to be picked on, you had to show people around you that you were capable of engaging in the kind of violence that would dissuade you being assaulted. And that was just an expectation of being a boy. Like that was just, like, if I didn't want to get beat up, I had to show that I was capable of beating somebody else up. And then other people wouldn't want to beat me up, or they would think twice about doing so. And that is just literally like, that was, a thing that just like dominated, a large part of my young life was just that expectation. And I don't think that's particularly unusual. I'm not saying I'm persecuted here. I think that that's just how a lot of boys grow up in the United States. And reading the book, something that struck me that I wanted to ask David about is like, there seems to be a contradiction between the traditional images of American masculinity and the way the way that your capacity for violence is ennobling as a man. And the bipartisan conviction that David describes in this book, that violent crimes render a violent offender incorrigible beyond, the ability of the state to rehabilitate. And I'm wondering if you could talk a little bit about that, because I just think, I just think that it's so interesting to me to see, in some ways, some politicians talking about a certain kind of violence in a way that they consider valorizing, which is the kind of thing that if someone else did it, even in those terms, based on those justifications, would land them in prison for a very long time.
Yeah, absolutely. There's a lot of cognitive dissonance there. And I think the way that that gets managed often, typically, is by not calling the good stuff violence. So being tough, being strong, those are good things. Violence is bad thing, is bad. So what winds up happening is that the same activity gets called violence if it's done by somebody else. And it gets called strength or virility or masculinity or toughness when it's done by our side. And, this is one of the many things that Trump in some ways performed a service by saying out loud for us. So it's easier to see when in Trump's case than in the case of people who aren't so blatant in their inconsistency. But I think that the inconsistency can be found in the way all of us think about violence. We all tend to use the term violence for the stuff we don't like, for the stuff that we think is a reflection of somebody's bad character, as opposed to a manifestation of them being tough and strong in circumstances where they need to be tough and strong.
Which raises an interesting question, David, that I'd like to ask you, but others may have comments on this too. Because the book and the conversation we're having is both about ideas, but also about the machinery of institutions that coerce, that police, that judge, right? That restore, perhaps sometimes, maybe too rarely. I guess I wonder how you think about what you would treat as an appropriately ambitious but realistic agenda on the reform side, and not so much on the intellectual side. On the intellectual side, I grasp, I think, what your ambition is. It's provocative in its own right and not inconsequential, because it goes to how we educate law students. It goes to how we write and think and theorize. But on the reform side, like, do the following thought experiment. Let's suppose that we're 15 years into the future and some associate professor at Stanford is writing a law review article about the great reforms that occurred after a pattern of violence hit the bookstores. And tell a story of what those reforms were and how they came about.
Okay, so the first step in my utopian story would be that we stop using violence as a master category. So that when people talk about violent, for example, if somebody says, wow, violent crime is really rising during the pandemic, the response should be, that's not, violent crime is not a helpful generalization. Are you talking about intimate partner violence? Are you talking about homicides rising? Because then we should talk about that. And I think that idea that we could stop using violence as a master category, it's realistic to think that might happen because it's what other countries do. Other countries don't place as much faith as we do in the line between violence and non-violence. In the UK, for example, which has many of the same pathologies in their criminal justice system that we have, one way in which they're better off than us is they don't tend to talk about violent crime. If there is a discussion in Parliament, they will have a discussion about serious violent crime, or about gun crime, or about knife assaults. And I think just disaggregating the category of violence in that way does a lot of work, because it prevents you from thinking that this is a neutral category, And it prevents you from thinking that people who fall within this category are beyond the pale. And it's extraordinary how easy it is for people across the political spectrum to fall into the trap of thinking that people who have been labeled violent criminals are fundamentally different. I mean, during the worst public health emergency of our lifetimes, when we knew that prisons and jails were going to be vectors for the spread of this virus, Gavin Newsom said, I want to be very clear about this. I have no interest in releasing violent prisoners early from prison. So this isn't just a mistake that's made by Republicans or by people on the right. It's a mistake that gets made across the board. And so once you stop making that mistake, I think it becomes much easier to say, well, we shouldn't have such ridiculously long sentences for many of, well, for any crimes, but certainly for many of the crimes for where we currently justify it by categorizing them as violent. I mean, if we started talking about what should be the sentence for somebody who's committed 2 burglaries, that's a different conversation than what do we do with repeat violent offenders. So what would the reforms be? It would be, we would be reducing mandatory sentences, eliminating the mandatory nature of them in many cases, greatly widening the opportunities for parole, greatly widening the opportunities for clemency. It would mean seriously addressing violence inside prisons and not thinking that it doesn't count as violence because the victims are people who have been convicted of crimes. That's where I would start. I also think that, once we realize that violence is an evaluative category and not a simple descriptive category, it means that we need to start thinking about what kinds of police conduct we want to call violent and how we want to address it.
David, I know this seems like maybe it's an obvious question, but you write in your book, the most important of these mistakes is the assumption that violence is a thing apart, an easily recognizable, objectively distinguishable, superlatively condemnable set of behaviors engaged in by an easily recognizable, objectively distinguishable, superlatively condemnable category of people. My question to you would be, why not? So I'm not saying that I didn't find your book persuasive and convincing, but if you're like just a random person who's like, wait, why is violent crime not completely different from all other kinds of crime? Like, why should we not consider it a completely different category?
So I think there are 2 things. First, I think that the line between what counts as violent and what doesn't count as violence is often blurry. And the reason why it's blurry is that we want it to do so much work. If we didn't expect it to do so much work, there wouldn't be as much pressure to try to include things, to try to categorize some things as violent that don't match our ordinary everyday meaning definition of violence. And conversely, there would be less resistance to using the term to describe things that we think might be defensible. But the other half of why it's a mistake to try to draw the simple distinction in the way that I say in the book and that you quoted is we often talk as though the problem of violence is a problem of violent people, that violence comes from their very nature and not from the circumstances in which they find themselves. We say that about the violence that we don't like, the violence we want to condemn. Whereas when people use force or are tough or strong in circumstances that we find sympathetic or admirable, we tend to describe it as a response to the circumstances in which they find themselves. That's a big part of the story about police. A lot of police violence is not called violence because it's viewed as a response to the circumstances in which the officers find themselves. And I think just as it's a mistake to think that the line between violent crime and nonviolent crime is sharp and non-objective, it's a mistake to think that the people who commit a crime of violence are defined by that offense. Somebody who commits an assault is a violent criminal and has committed an offense that comes from his very nature. Whereas we don't say that about lots of other crimes that people commit, and we don't say that about people being tough or vigilant in circumstances that we find sympathetic.
I guess as a follow-up to both sort of your answer to Tina's question, and also with Adam's question, is that one thing that was striking with the suggestions you were giving, it seems like they were giving a lot of discretion to then folks in the system. But I'm just thinking, going back to your Gavin Newsom example, if Gavin Newsom said, okay, so I am going to release the people who are in prison for homicide and burglary and rape, right? So specifics, right? So not saying that like I'm going to release the people with violent crimes. I don't think that he would do that, would he? Because of the backlash that would happen.
Well, I think he could have said public safety is hugely important. We're dealing with a public health emergency, but obviously we don't want to release people who can't be safely released. Mm-hmm. So we're going to need to pay careful attention to who we are releasing early and make sure that we're not gambling with the public safety. But at the same time, we need to address a public health pandemic. I think if he had said, I don't want to release convicted murderers, I don't want to release convicted rapists, I would have less of a problem with that than with saying we're not going to release violent criminals, because that would at least be disaggregating. But I think even that would be a mistake because I think that you're dealing with human beings, with people who have been sent to prison because they've been convicted of doing bad things, but they're people. And look, one of the reasons why we have mass incarceration is that we keep people in prison for unbelievably long periods of time, well past the time when they could be any danger to anyone. I mean, if somebody's, no matter what somebody's been convicted of, by the time they are 75 and confined to a wheelchair, they're not much of a danger to anyone.
And when I think about how to interpret the level of ambition behind that argument, it feels to me like it's like looking at a picture on a page that, depending on whether your gaze kind of focuses on one detail or another, it looks a little different. Like on the one hand, I hear an argument about the importance of taking the violence problem head on, deconstructing violence, being more honest about how different kinds of criminal activity we lump under violence really work, thinking seriously about how we treat the violence category differently in policing, in prisons, and so on. On the other hand, I sense a greater ambition, which is to take the violence issue as a way of making a broader and deeper argument about criminal justice and incarceration. So here's where, in particular, I hear the key of your point about situations and the importance of them. And what's interesting is I don't hear you saying primarily just, let's think about the situation in which we've placed a child over the course of her entire life. There's a bit of that, but there's also a sense of, let's understand what it is that bears upon a person, as psychologists tell us, sociologists tell us, and then causes things to happen, and try to situate more the policy levers and the concern in that broader discussion.
Sure. Yeah. And by the way, I mean, we should be doing that with police also. because a lot of the debate about police violence takes place between people who think we're dealing with a few bad apples who are fundamentally violent, and the rest of police violence is just a response to the circumstances in which police find themselves, and people who think that police violence is a reflection of a fundamentally violent group of people as a whole, the police, a fundamentally violent occupation. And what gets left out of that debate are the circumstances in which officers wind up finding themselves because of police tactics and training. What gets left out are the ways in which violence can grow out of circumstances that the law itself creates. For example, we've made a choice in this country to use traffic stops as a form of dragnet policing. We give police enormous discretion to stop people for traffic violations, and police are trained to use that discretion as a tool, as a lever, as a way to investigate. And police are trained to look beyond the stop. So what that means is, if you're whatever violation you're stopping somebody for, don't think that that's the only thing you should be looking for. You should run a warrant check. You should maybe, and you never know. You could be stumbling upon somebody who is engaged in some more serious crime, and it's because we use traffic stops in this way, because we create the opportunities that too often cycle into homicides, and that's a kind of, when you think about policing that way, when you think about the police, what tactics we have, how we train the police, what we ask them to do, and in what ways that winds up creating opportunities for violence, you come up with different sorts of reform levers than when you're just trying to figure out, are we dealing with a few bad apples or with a rotten occupation?
So I want to get some of the Q&A from the participants on here, and it seems like sort of the question that people have been voting on the most is in line with this conversation thread, and it has to do with prosecutors. With respect to progressive prosecutors, how do we then sort of think about violence in terms of alternatives to incarceration for violent crimes? So many of the so-called progressive prosecutors are diverting cases out of the system in an effort to reduce the incarceration rate. But other than restorative justice programs for some juvenile cases, are any of these prosecutors diverting cases involving violent crime out of the system? And if not, what does that mean? What are the repercussions of that?
Yeah, some of them are, and they get flack for it. So Eric Gonzalez, the district attorney in Brooklyn, has been diverting some low-level gun offenders from the criminal justice system in Brooklyn. And the mayor of New York City, Bill de Blasio, took time out from his own presidential campaign to criticize Gonzalez and say, I think that diversion is great, but not for violent offenses, in a category in which he included any offense involving a kid who's found with a gun. And Gonzalez's position was, guns are a huge problem, and kids with guns are a huge problem. But that doesn't mean that every kid who's found with a gun should be prosecuted and sent to prison. I think he was right about that, and I think we should be encouraging more efforts like that.
Absolutely. And I think it really just some of the progressive prosecutors who are willing to take that political risk need more data from the nascent restorative justice and other diversion programs that work with violence. Right? There are some programs, including the work that I helped build, where we work with people who have caused violence and harm that is really severe, right? And felony level harms and violence. And the data is showing that these diversion programs are actually more effective. And so if we can build more and more of this political cover for the DAs with like facts that show that actually incarceration doesn't reduce violence, it doesn't help in these types of cases, and that actually restorative justice and other types of diversion programs are much more effective, that I think that would be helpful for DAs to be able to take that risk. But the DAs who do take the risk do get a lot of flack for it. And, I'm grateful for those who are willing, and particularly to do so sort of in the pre-charge context, again, where we're circumventing the system. Because sometimes I think trying to do these reform approaches too entangled with the system means that we're dealing with we're having to deal with all of the statutory definitions and all the things like Brady and all this, where it doesn't really operate well in the context of restorative justice to have to also be juggling these things. It both harms restorative justice, and I think it produces less good outcomes. But it does take a lot of courage on the parts of DAs, and I think that the more that we can build these programs and offer data back to show the effectiveness, is going to be helpful in that regard.
I just want to observe it's been interesting to see how the discussion of criminal justice reform has come to encompass police and DAs, and there appears to be an appreciation that the problems are similar but complementary. At the end of the day, both sets of organizations face incredible complexities, strong and entrenched cultures, a lot of sensitivity to communities and pressures and political dynamics. And I just feel like it's a thoughtful, important piece of the conversation to recognize that we've disaggregated a lot of responsibility in criminal justice. Institutions like mine have some, prisons have some, police have some, prosecutors have some, but prosecutors do have this unique and distinctive opportunity to sort of make a case about what their reform program is to the public in a way that is rare for others to be able to do. And I think that it's appropriate to ask how that conversation, that public conversation, can have concrete impact.
Adam, I'm thinking about your work where you are not only identifying individuals that cause violence or harm, but then also dynamics such as sort of racism that are catalysts for groups of people to enact violence against others. And also calling activities that have happened as things that are harmful. So if we're thinking about, say, the riots that happened in January 6th, or talking about the violence that happened after the Civil War. So I'm just thinking about sort of the push and pull of this, right? So on the one hand, it seems like we want folks to stand down, right, to go in other directions, but it's also that you are calling attention, highlighting sort of harms that we may not necessarily address as much. So what should we do with those?
I'm afraid, so, when I think about January 6th, I think what's so interesting about it is that the response to it in some ways goes to the dynamic that David describes at the beginning of his book, which is that violence, and in particular political violence, is very unpopular in the United States. How do we know this? Because even the people, even like Trump supporters were trying to say, oh, the Capitol riot was a false flag by Antifa. So that's an indication that political violence is unpopular, because if it was not that, then they would be saying something else. They would be saying what people said, during and after Reconstruction, which was, we had to do this. We had to do this to save the country, to save the state. It was necessary. And part of what happened there was that the Capitol riot failed, but it's simply also the case that political violence carries a tremendous stigma in the United States. The flip side of that, of course, is that there are forms of political violence that we have outsourced to the state in order to prevent them from being questioned. So, when a police officer, we saw examples of this, published videos all over the New York Times during these protests in the summer, when police were using excessive force against protesters. That is a form of political violence. It's something that, the earliest academics were studying police culture. The thing that they found most, that police, this is in the 1950s, 60s, the thing that they found most often that police justify the use of extrajudicial violence against suspects was disrespect for police. So it wasn't, this guy's a rapist, he has it coming, or this guy's a murderer, he has it coming. It was, you disrespected me and I'm a cop. And that, that's kind of a form, that's a form of political violence. And I think, on the one hand, the United States has a very violent history. On the other hand, and there's a tremendous amount of violence in American society today that has sort of been, that we don't see that way because it has been bureaucratized or become a part of the state. But we're also not facing what, what Ulysses Grant was facing when the Department of Justice was first founded, when he's facing a literal insurgency in the southern United States. The first Klan is the closest thing to ISIS that has ever existed on American soil in terms of a non-governmental body that is engaging in an insurgency against the state using terrorism. It's just, there's almost nothing like it. So we're not in that kind of situation. I think the larger issue is that we have, and this is something that David talks about in his book, is that we have internalized a sort of racialized conception of violence that places certain acts of, that valorizes certain acts of violence and then places others beyond the pale without too much consideration of what we're actually endorsing or condemning. And I think that is more a political problem than something that can be solved necessarily with law or violence or anything else. It's fundamentally a question of politics. I hope that made sense.
Yeah, you wrote this book mostly while Trump was in office, and now we have a different administration. So would it be a different book, and how so, if you wrote it now?
Well, I would talk about January 6th a little more, because I think that it illustrates a lot of the themes in the book. I think we face a different set of challenges now. The challenge now is that because the abuse of the category of violence isn't so flagrant and so obviously politicized, we may become more comfortable with it again, and we shouldn't. I think what Adam said about the political uses of the category is absolutely correct. That Senator Ron Johnson gave maybe the best recent example of this when he said that he didn't find the events of January 6th frightening because the people at the Capitol were law-abiding, whereas if there had been Black Lives Matter or Antifa protesters, that would have been scary to him. That's the problem with thinking that violence is this master category. It's that it's too easy to include your enemies in the category or your opponents in the category, and to write your friends out of it as law-abiding, as strong, and not as violent. So I just think that we built up this category of violence in Republican and Democratic administrations, no administration did more, I think, to build this distinction up than the Clinton administration, which did a lot of good in a lot of ways, but President Clinton, as a candidate and as a president, reflected and acted on the idea that it was fine to try to move forward criminal justice reform with regard to nonviolent offenders, but not with regard to violent offenders, that we couldn't give any quarter violent crime, and that it was that mentality that allowed that I think planted the seeds for the ultimate collapse of police reform, and that drove a lot of the mass incarceration that we're living with today. So now, when we have an administration that is in many ways well motivated, that doesn't fall prey to the worst aspects of race baiting and the most blatant forms of politicizing of criminal categories, now is not the time to think, well, we can fall back on an easy category like violence to distinguish the really bad criminal defendants from the ones who deserve understanding and lenience.
David, I'm wondering if you would think that also eroding this idea of character or dispositional entirely, to get rid of that idea that there is like a fixed disposition, would also serve that positive end. The same, it's another way of getting rid of the category of violence entirely, because it seems like that might be a reform that would be beneficial across the entire world of criminal justice. And if we get rid of violence, I worry that we would just fall back on character, which could then also play itself out in race ways. And so, you know, to my mind, I have personally rejected the notion of disposition or character, and rather see everything as situational, and that there are infinite causes and conditions, that we can't get to all of them, but that if we can be as broad as possible in the examination of causes and conditions with regard to every single human being that we come in contact with, we could also solve this. So I'd be curious your thoughts on that in relationship to this. There's another theme that I kept throughout the book.
I think it's absolutely true. And look, as lawyers, as somebody who still is in the legal profession, I deal with the reality that people do have characters, people do have dispositions. Some people are more violent than other people. Men are more violent than women. Young men are more violent than older men. So it's not as though there's no such thing as disposition or as character. But what is true is that we are much too quick to think that violence is explained by and grows out of somebody's fundamental character, as opposed to the circumstances in which they find themselves. And I think you're right, Sujatha, that addressing that and understanding that is really important. And to some degree, it's as simple as understanding that people who commit crimes are people who commit crimes, and that you can't understand what happens, and you can't think sensibly about how to move forward if you ignore the fact that there is a person here who committed the crime. And that doesn't mean ignoring the crime. It doesn't mean forgetting about judgment, but it does mean always keeping in focus that we're not just dealing with an act that comes out of somebody's fundamental disposition. We're dealing with a human being.
And I find, Sujatha, your comment really important. I am reminded, though, that part of what makes this conversation so interesting is that we're dealing with the economy of actual concepts that operate in the law, as well as the economy of rhetoric that people use. So I'm thinking, for example, apropos of situations about a police chief. And I can see why even a police chief who has read David's book, who embraces David's book, even a police chief who is David, might say, you know, your actions reflect your character. They reflect your fundamental sense of right and wrong, who you are. They reflect on our department, they reflect the situation, but they really reflect what are your values. And I'm sort of like embracing your observation, but still wondering about the rhetorical and practical dilemma of a person in that position.
Yeah.
So as we are drawing to a close, and I know that we can all have sort of hours, days, years more conversation, sort of thinking about this. I just want to let David, if you want to have any final thoughts here.
I just want to thank you, Ravi, again, and Sujatha, and Tino, and Adam. This has been exactly the kind of conversation that I was hoping that the book would spark. I think that, as Tino said, these are hard problems. And the most important, the biggest mistake is to think that this is all simple, that there are violent people and non-violent people. And if we can get away from that, if we can start recognizing the complexities that are involved in violence and in violent crimes, I think we can move forward.
Thank you, David, and thank you to a wonderful, thoughtful panelists, to the hundreds of participants that were part of this. So
great job, Rabia.
Thank you.
Bye.
Bye.